that
I hate
today
it.
I have to conduct my part. I'm ready to do it,
Hmm.
but it will take more than 1 hour and so
Hmm.
lengthy, because they have given us so many judgment.
Hmm.
I have to distinguish that apart. There are 3 different statements with regard to the accused person.
Hmm.
In one place, he said he has taken the money for charity. In another place, he said his friend has given him money for purchasing a gold ornament. In another place, he has said some party has given him to purchase the machine.
Hmm.
I have to show your lordship this statement, 3 statement. However, till SD statement in defense, he is not able to justify the recovery at that amount.
So,
But-
any difficulty to do it today?
I can do it, but one matter is there in court number 10. It's still going on from the morning.
Oh,
So I will have to complete that, then I will come. So since the item is last one, so at all, if it at all is start, it will start by 3
so
o'clock.
again, not possible.
Cannot be possible to complete.
It's better than that we sit from the first half, from since morning, and then we can take it up.
Submission, this may be recorded part continuing.
You had started, right, last
Yes,
occasion?
yes, yes. In this manner, I have started. That there
But
are 3
otherwise, I don't
statements.
remember. I'll have to begin.
So these 3 statements, and all 3 statements are different statements given by the accused himself.
So, okay, we will do it at one go on 2nd of June then. Okay. So, you inform the other party. You are there for the... Acha. Okay. You inform them that you have
Definitely.
time is granted. So,
2nd June, your lordship.
okay.
Much
As prayed for by learned counsel appearing for the respondents, list this matter again on 2nd of June 2026. Okay.
Much
Which is not objected to by Etu Didiva, which is not objected to by the learned counsel appearing for the petitioner.
I shall inform.
Yes. Any objection, let me know. Yes.
Item number 6.
So that was item number what? The one that was just mentioned? This is yesterday's list. This is yesterday's list. Oh, 20, huh?
Item 20. Not
Item 20.
Yeah. That
Then
is,
what
it will
again?
reach by 3 o'clock, and then it is very
Difficult. Again, it will spill over.
Much up.
Just a second, let me get my cause list. Nine? It was there in my chamber. Acha, what do you want to mention?
Item number 6.
16.
6.
6.
Okay.
So why?
Our senior MK Chaudhary has some difficulties in conducting the matter today.
6. Okay. 25 matter for admission. Okay. Your Mr.
Argo.
R. Gauhati. Mr. R. Gauhati, learned counsel appearing for Mr. M.K. Chaudhary, learned senior counsel for the petitioner, submits that Mr. M.K. Chaudhary, the learned senior counsel, is indisposed today and has prayed for some time. Prayer is allowed. List this matter when?
Any date, Lordship.
List this matter. You suggest a date. Matter on what? Next to next week, 21st of May? 21st of May.
Good pleasure.
Yes.
Item 1.
What happened? You had both.
I
Uh-huh.
am the read petitioner.
Yes.
IA
You
has
both
been
have
filed-
entered into some agreement?
IA has been filed by her for impleachment, but no copy of the IA has been served on.
Oh.
Without serving copy, he cannot file.
I don't know who has received the copy. madam.
Doesn't matter, he has not got, give him a
Yes,
copy.
that,
Yes, I-
For impletement.
Yes, my
for impleachment.
Whether you are the necessary party.
lordship.
Okay, let him go through, then we will decide.
Yes,
Yes, lordship.
Okay. Then we can take it up next week.
next week.
Heard Mr. Ali, S. Ali,
Yes, Islam.
as Islam, learned counsel for the petitioner, and Mr.
Yes, Ali.
No, you in the IA you say, huh? Heard Mr. S. Ali, learned counsel for the applicant, and Mr. S. Islam, learned counsel for the respondent. Mr. Islam submits that a copy of the impleading application has not been served upon him. As such, it is directed that the learned counsel appearing for the applicant may serve him the copy at the earliest. List this matter again on, when do you want then?
Next week, on any day.
List this matter on 14th of May,
14th.
Thursday,
Right, sir.
next Thursday. Next, repetition লিখি দিবা এনে যে matter is fixed on 14th. Item 2, Mr. Mahanta, Mr. TJ Mahanta is there.
Hello, I'm completely sorry for interrupting. Apparently, item 20 has been mentioned that
Yes,
2nd of
yes.
June.
Yes, 2nd of June.
So, my lord, if possible, can we have it on 29th instead?
29th?
Of May.
That's a Friday. Because I want to finish it at one go, because if it spills over on the next day, it will be again on Monday.
Okay.
So I thought of giving it 1st June. I don't know, it's marked as blue. So 2nd June.
My lord, then may I get some time to consult with the
Okay.
council? So
Let me know.
yes, ma'am.
After
Okay.
consulting. Okay. Yes, item number 2. Yes, Ms. Mushari. Item number 2, councils are not there. Achha, TJ Mohanta, let it be called up after some time. This instruction is in relation to item 2. Let the council come. Item 3. Yes.
May I please, Your Lordship?
Huh.
This one is filed for the retirement benefit.
This is a bench tree matter. Is this a bench tree matter? It was reflected in the last order. It is submitted by the learned counsels for the parties that this matter pertains to bench 3. I'm taking up bench 2. Right. Whereas the roster assigned to this court for the current week is bench 4. And list this matter before the appropriate bench. Wait. Let me verify and pass the order. It was reflected in the last order. You're for the respondent? Acha. You're for the secondary education?
Yeah, no, accounting general.
Oh, accountant general. Acha, this is item 4, no? Item
Step 3.
3. Acha. You check up and let me know whether your matter belongs to bench 3. Okay. Let me know before I rise. See the last order.
Supposed to get instruction, let's see. The claim of the petitioner is for pension under the old pension rules, which is 1969. Initially, she was appointed in 1993. Thereafter, her service was provincialized in 2005.
Hmm.
And after appointment, lordship, she received salary, lordship. And the similarly situated teachers also, they have approached this honorable court, and this honorable court directed to pay the service benefit under 1969, lordship. So on that
Not
account-
under the new scheme.
No, not a new, under the old scheme, lordship, 1969. They're supposed to get instruction.
Lordship, I need some time to obtain the instruction. Kindly grant 2 weeks time.
This is a very small instruction whether they are entitled under the old pension scheme or
New
new.
pension.
And there are batch of other petitions wherein that was allowed.
Lordship.
So get the instructions soon. Allowed to file their respective affidavits. Affidavits are not filed.
Not,
Not filed. Lordship.
None of the parties are filed.
No.
Okay. Yeah, Miss Decca.
Miss
Eh.
B. Deca.
B. Decca, learned counsel for the
1 to 4.
You are for which department? Elementary education.
Lordship.
The standing counsel for elementary education has prayed for some time to bring the necessary instructions. Prayer is allowed. List this matter. When can you bring it? Bring it soon.
Lordship.
Matter of pension.
After 1 week, Lordship.
List this matter on 14th of May.
Lord.
Next Thursday. You'll be able to come. Bring
Lordship 18.
18th. Okay, 18th is a Monday. 18th of May.
Lordship. Obliged.
Right.
Where is the petitioner's counsel? J.U. Ahmed. What happened?
Lordship,
3 weeks time to file affidavit by the last order, but no affidavit. I can see it here.
Lordship, that time the instruction was awaited, Lordship. So,
You are for
social justice 1 and 2.
Social Justice Department. You will file the affidavit also.
Lordship, 2 weeks time may be granted. We will file.
Only the instructions will do or affidavit you want to file?
Affidavit we want to file.
Okay. None appears on call for the petitioner. However, Miss
A.
Mm.
Sharma on behalf
A.
of
Sharma.
RM Das Lodge.
However, Miss A. Sharma, learned counsel on behalf of Mr. R.M. Das, learned standing counsel for social welfare, social justice department, prays for some time to get the instruction as well as to file the affidavit. Prayer is allowed. List this matter on 21st of May. Okay. 26. Yes, Mr. Bhuya, what is this about?
My lord, this is the petitioner is in a very, my lord, serious bedridden condition, my lord. My lord, the case is about that the petitioner's service was provincialized as a superintendent of a erstwhile senior madrasa, my lord. Now, my lord, the services of the petitioner, while before his provincialization, he was under suspension by the managing committee that had been approved by the director, and treating him as a suspended employee, his services had also been provincialized.
During his suspension
During
period?
his suspension, my lord, the order reflects as such. my lord. Now, my lord, the reason for the suspension was a criminal proceeding instituted against him. And in that criminal petition proceeding, my lord, he has been acquitted recently. my lord. He was under a impression, my lord, that he will be reinstated in due course and will given the benefit of the service and other provincialization benefit which he is entitled to. My lord, when we preferred this petition before this honorable court, with the prayer, my lord, that I should be reinstated as well as my subsistence allowance and other benefit which I am due, my lord, should be paid to me. So, my lord, then this honorable court made an observation that the, my lord, at least the subsistence allowance should be given to the.
Subsistence allowance was not paid during his.
My lord, till date, nothing, not a single paisa had been paid to.
But when somebody is under suspension, his subsistence
He's
allowance.
he's entitled, my lord, under the rules, my lord, FR is applicable.
I thought you were talking about the remaining amount. No.
No, my lord, remaining amount, my lord, if I am reinstated before my superannuation, then, my lord, that can be my suspension period is, my lordship knows, my lord, that it is required to be regularized. Then only I can claim. But now I am in such a situation, my lord, that neither my service had been reinstated nor the earlier provincialization order had been given effect to. Now, my lord, what has happened during these courts, there was a series of litigations where they are before this honorable court regarding challenge made by the present batch of petitioners and other petitioners also regarding their suspension as well as terminations. And this honorable court, my lord, came to a conclusion that the provincialization order to which, my lord, we are seeking the benefit is had been interfered with by the, my lord, this honorable court and directed for a de novo. Now, my lord, now when the affidavit has been filed by the state, just, my lord, we have come to know that though a de novo district scrutiny committee report had been prepared, my lord, but there is no final decision had been taken by the government for the purpose of fresh provincialization of all this set of employees, wherein, my lord, I had been left out. So now the situation is as such, my lord, the earlier provincialization order wherein my name reflects still survives, my lord. On the strength of that provincialization order, all the employees still they getting the benefit excluding me, my lord.
Maybe because your provincialization was already there.
No, no.
So you are not included in the letter.
My provincialization is also there, my lord.
Ah.
Just for a moment, if I beg to draw my lordship's kind attention, my lord, is at page the provincialization order, my lord. Annexure 1 to my petition is at page 19, my lord.
Achha, Ms. Mushari, you have filed your affidavit
Lordship,
Yes,
we are
yes.
fine.
and you are ready with the case.
Lordship.
So this is your erstwhile, right?
Erstwhile provincialization order
During the period of your suspension.
suspension. My lord, may I kindly see, my lord.
Hmm.
MD Fakhruddin Laskar, so and so, MM,
Where?
HSLC superintendent.
Oh, yes, huh?
Designation as a superintendent, date of appointment, everything has been mentioned, my lord. And if I may be pleased to beg to draw my lordship's attention, my lord.
Date of appointment was
No, my lord,
2001.
This is not the provincialization order. This is my approval of my appointment, my lord. The provincialization order, my lordship may be pleased to find.
This is approval of appointment.
Approval of appointment, my lord. I'm sorry, the provincialization order starts at page 36, annexure 6, my lord. And my name, my lord, is at page 37.
Wait, just a minute. I'm
My
going to
lord.
take out. 36, yes.
37 is the, my lord, relevant part.
23 numbers of
Yes, yes, madam.
teaching and non-state has been created under the provision of madrasa so-and-so as amended under the hereby allotted to senior, okay.
My lord.
Hmm.
Now, my lord, these are the breakup of the post for a particular, my lord, district or the madrasa institution. Now, my name
Hmm.
for Silchar Senior Madrasa, my lord, the services of the following incumbents have been provincialized, my lord. With
Where,
effect-
where?
I am reading at page 37 top. my
Oh,
lord.
yes.
The services of the following incumbents have been provincialized with effect from, my lord, may kindly note the date 1/1/2013
Hmm.
against the above mentioned allotted post created by government letter number dated so and so.
Hmm.
Name of incumbents, Fakhruddin Laskar, superintendent under suspension, my lord.
Hmm.
HSLC so and so. So this is the order by which I had been provincialized as under suspended employee, my lord.
Hmm.
So now once provincialization is there, I am a government employee, my lord,
Hmm.
under the provision of
Hmm.
the act. So therefore, my lord, my claim is that once I had been, my lord, provincialized as a, my lord, government employee till date, they are ought to have at least give me the, my lord, minimum benefit of the subsistence allowance that has not been paid, my lord.
Thereafter, what happened to the inquiry?
Thereafter, my lord, I was, my lord, waiting that the department may take up no departmental proceeding, no charge memo, nothing, my lord.
Acha.
And on the last occasion, my lord, I have been acquitted of all the charges for which, my lord,
That is
I
the
have been-
criminal proceeding. This
Criminal
is a
proceeding.
departmental
No, my
thing.
lord, they can
Huh.
proceed parallelly also, but that
Huh.
parallel proceeding they have also never initiated against me, my lord. Now, my lord, I am on the verge of superannuation and I am a bedridden condition, my lord. It's very pathetic condition, my lord.
So you have also annexed the acquittal order?
Yes, yes, my lord. My lord, may
Acha,
be
it's
pleased
okay.
to find is at page 45, my lord.
Uh-huh.
Page
Where
45.
is the acquittal order last?
Acquittal order, the last part, my lord, may be pleased to find is at page 76, my lord.
Hmm.
Order.
Yes.
Page 74, my lord.
Hmm.
On the strength of the deliberate discussion made above, I am of the considered opinion that MD Fakhruddin Laskar petitioner, my lord, and A2 Abdul Wadud Barbhoya are found not guilty of the offences punishable under section so and so, so and so, so and so. Accordingly, so and so Barbhoya
Acquitted,
acquitted from the
okay.
charges under section so and so of the and are set at liberty forthwith so far as the case is concerned.
No appeal against that?
No, my lord, till date state has not preferred any appeal, nor the informant, my lord.
Hmm. And you were saying about some writ petition filed by similarly situated or
My lord, that writ petition today, my lord, I could not bring.
any order of that writ petition
Yes, yes,
annexed
my lord,
here?
there is an order, my lord, that WPC 493, my lord, 2000,
Not annexed here.
it is not annexed here, my lord, because this is only for the WPC 490 of 2013, my lord,
Hmm.
and this was disposed on 26/8/2016.
Hmm. Saying what?
Saying what, my lord, that the provincialization which I have just brought into my lordship's notice had been interfered with by this honorable court, saying that the director has no power, it should be by the government.
Acha, that provincialization was set aside.
Directly not set aside, the court has said it was not in accordance with the law. So therefore, this provincialization order cannot be, because, my lord, in all these type of educational institution, provincialization order had been passed by the director.
But
only-
anyways, there is an order.
There is an order.
The
There is an
director
order.
cannot pass provincialization
Exactly,
order,
my lord,
but the
exactly.
government.
Exactly, my lord, and my lord, I will not suppressing anything before my lord, my lord. What the issue is that once the order had been interfered with, there was another mandamus had been issued by this honorable court directing for a de novo. And only.
De novo
only
what?
in
De
this
novo?
affidavit, my lord,
De novo what?
de novo provincialization exercise
Oh,
should be
acha.
carried out.
New one. So
My-
that list that you have shown goes.
No, in that list now I have come to know from this affidavit, my lord, recently, because it is never being, my lord, served or furnished to me. Only when this affidavit had been filed, my lord, at page 88, this de novo exercise, initiation of de novo exercise had been carried out, wherein, my lord, I had been excluded.
Okay, 88 of her affidavit.
88 and 89 is the relevant part, my lord. My lord, may kindly peruse the head of this, my lord, proceeding of the meeting of the district scrutiny committee for Silchar Senior Madrasa held on 21st of February 2019 at 4:30 p.m. in the office of the Deputy Commissioner Kachar. My lord, may kindly note the date. This is of 21st of February 2019. And my lord, the order was passed on 26/8/2016 after a period of 3 years, my lord, they have taken up. Now, my lord, this is just the initiation of the proceeding, and this proceeding culminates, my lord, by recording the name of the teaching and non-teaching staff of the employees. Altogether 19 numbers had been, my lord, mentioned, but unfortunately my name had been excluded in this proceeding, my lord. I don't know for the only when.
Maybe
this
because you
affidavit-
were under suspension.
I am under suspension, but my lord, once I had been provincialized, my lord, that then it will equally applicable to all the employees, my lord, at par.
These other employees were also suspended.
No. Other employees not suspended, but my lord, once I had been provincialized and given the status of this honorable court never interfered with my provincialization. As a whole, everybody had been treated at par, my lord.
So as a whole, yes, you
Right.
were not specifically said, but then that provincialization list goes.
Yes, sir.
And when goes,
My lord.
and a new de novo exercise was ordered,
Taken.
and then maybe they found you under suspension, so they did not include you.
No. Then, my lord, this, my lord, not only the issue is regarding this de novo exercise has not culminated into finalization, my lord.
Hmm.
What they are required to do, my lord.
It's kind of a premature.
My lord.
Your application is kind of a premature. This is not.
My lord, this has never been brought into my notice, my lord. Only
Acha.
when the affidavit has been filed by my learned
Hmm.
friend, then only I could come to know about this. Now, my lord, my respectful submission regarding this proceeding is that this is not the finality of a provincialization, my lord.
Hmm.
My lordship knows that under the 2013 Act, there is a district committee, then the committee's report is required to be placed before the state committee, then director, then government, then provincialization order, my lord. Now, this is only the minutes of the district level scrutiny committee.
Hmm.
Thereafter, my lord, there is no any such, my lord, development I could see from this affidavit filed by my learned friend, my lord, that the provincialization order had been passed. So therefore, my
That
lord,
has not been passed.
Not been
Not
passed.
It
been
took
passed.
3 years.
Not been
Now
passed.
it will take another 3 years.
My lord, my limb of argument in the issue is that, my lord, once this order has not been attained into finality, so therefore nobody can get the benefit.
Hmm.
As the provincialization order has been interfered with. Now, excluding me, all the teaching and non-teaching staff reflected in this 19
Hmm.
numbers, they are getting the benefits also, my lord.
They will get,
They will get because on the strength of the earlier provincialization order.
subject to this approval.
Which-
Right.
which
Now,
approval?
this is only a minute of the meeting.
Minute of the
Subject
meeting.
to,
Minute of the meeting cannot be the, my lord, ground for giving the benefit of provincialization, my lord.
so these people also, you cannot say that they will be provincialized. It is up to the government.
But my lord, if we go by the provision of the law, my lord, and by the judgment passed by this honorable court, my lord, that the entire provincialization, nobody is entitled to the benefit, not only me, my lord, because the provincialization order had been interfered with, and this new exercise has not been attained finality, my lord.
No, you see, this is your case, right?
This is my case.
Now, this, what I can do is,
My lord,
the office
my lord,
has to take a decision
my lord.
as to whether to continue the disciplinary proceeding or what. Because simply his declaration as acquitted person
My
will not give him the right to be provincialized
disciplinary
or.
proceeding after a 20 years, my lord.
So let the office decide whether to.
Then, my lord, then I should be treated as a government employee, my lord. If now they are going to.
How can you be treated? Because the
Then, my lord, if I
provincialization
cannot-
list
my lord,
goes.
If I cannot be treated as a government employee, then the department also cannot initiate the disciplinary proceeding, my lord. The director cannot, I am not the employee of the director, my lord. So, my lord, my respectful submission before my lord is that as the earlier provincialization order, my name reflects, my lord, as a provincialized employee. Along with me, all the employees' name had been included, my lord. Now, although that provincialization order had been interfered with, not only for me, my lord, for the entire batch of employees whose name had been reflected. Now, after that, though they initiated a de novo exercise, my lord, but in that de novo exercise, they have deliberately left my name because, my lord, I am admitting that I am a suspended employee. Very good. But my lord, the rest of the employees whose name had been included and their name were also in the earlier provincialization order.
Yes.
So therefore, my lord, both the sets of employees along with me and along with the rest of the employees are at par. Now, my lord, depriving me from the benefit is a direct violation of Article 14, my lord.
But then there is a distinction. I mean, these people are not under any any
Well,
charges were against them.
No, distinction,
Now,
distinction in respect of the position of the service, my lord, not as a position of an employee, my lord. Until and unless position of the service suspended, but my relation with the government, until and unless I had not been terminated, will remain.
But whether provincialization can be done when a person is under suspension?
No, that can be done, my lord, because that can be done because, my lord, once suspended employee means, my lord, I have not been terminated. That has
Yes,
been done
not-
by the government, my lord.
Hmm.
I had not been terminated. That's
So what is your prayer here to include you in this?
No,
We
no, my
no
lord,
go.
my prayer is very limited, my lord. My prayer, my lordship may be pleased to find is that page, my lord. Page 16, my lord.
Hmm.
Set aside the impugned suspension of the petitioner, direct command the respondent to forthwith reinstate the petitioner as superintendent, and direct the respondent to forthwith make necessary for the purpose of payment of subsistence allowance.
That
and
is
salary.
okay. That is a reasonable prayer.
Fine.
Subsistence allowance,
Fine.
he should be paid.
No, my lord.
But setting aside that suspension order is not possible because let the government take care of it. Right. Let the government conduct the necessary proceeding.
Lordship, first of all, he was appointed by the managing committee and he was suspended by the managing committee. By the time he was suspended, the school was not provincialized. So he is not an employee of the government, your lordship. So the Assam discipline appeal rules will not apply to him. If any subsistence allowance has to be given to him, it will be by the managing committee, your lordship. Because he was appointed by the managing committee and suspended by the managing committee. And till now,
His services were not confirmed.
no, your lordship.
My lord, already provincial. I have already.
He was not provincialized, your lordship.
My
He-
lord,
Yes, but then it was interfered with. Now the
Interfered
position is that you are not provincialized.
no, my lord, interfered with not only for me. My lord, may kindly see
For everyone, saying
Everyone.
that director cannot do it.
everyone, my lord.
Director
So
cannot do
yes,
it.
yes.
Therefore, my submission of my respected friend submission that I was not provincialized, I was not a government employee, that is not correct, my lord. Because my provincialization by following a due statutory prescription of law under the 2013 Act, I had been, my lord, particulars had been processed as a suspended superintendent, and that approval had been given by the district level scrutiny committee, state level by the director and by the government. Then only this provincialization order had been issued. Now my learned friend is saying that I am not a government employee. This is not correct.
Lordship, that provincialization order was set aside.
Set aside, my lord, on a different context. If nothing
Yes.
remains, if nothing remains, then how these employees are getting, other employees are getting their salary, my lord? Can my learned friend bring on record that the other orders by which the other employees are given the benefit of salary?
See, Ms. Mukari, you bring the instruction as to why this
other
proceeding is not, no, why the proceeding has not started. You cannot keep a person hanging for years and years.
My subsistence allowance, at least they may be paid.
And
my lord. That-
subsistence allowance, where is your appointment order?
Yes, my lord. The appointment order, my lord, may be pleased to find. Approval I have already brought into my lordship by notice, my lord,
This approval by whom?
by the director, my lord. My lord, at page 19,
Madrasa, your lordship.
approval of appointment of teaching and non-teaching of recognized non-provincialized senior and title madrasa. This is Fakhruddin Laskar, my lord.
Wait,
They-
I'll just read the contents of
My
the
lord, my
order,
lord, at
subject to
page
creation.
19, I am reading, my lord.
Subject to creation of any of the following post of so and so, government in due course of time and without any financial implications for any of this been satisfied, the appointments made to the has been verified and having been satisfied, the appointment as a particular showing where none of the appointed shall be in any form without prior approval is incumbent upon the superintendent. This is actually not a regular appointment order.
My lord, what this system was there, my lord, knows, my lord. Before provincialization, all these type of appointments are made by the management committees, my lord.
Acha.
There is no other.
That is the practice.
That is the practice.
Earlier it was, your lordship,
My
might
lord.
be.
Now
might
those.
be.
And this was
Not now.
way back in 21 or what?
My lord. No, this is an order dated, my lord.
2003.
Your lordship.
Huh.
So, my lord, my appointment was made, date of appointment, my lord, can kindly note, it is
Four.
on 1/4/2001.
Hmm.
White resolution number 1/4/2001. So, my lord, this is the system in Venture Educational Institution in our state that the managing committee uses to give the appointment. And on the strength of that appointment only, my lord, services were being provincialized, my lord, under the various acts. So, there is no exception for me also, my lord, same procedure, my lord.
Acha, so can you bring instruction
Not sure.
whether the office is contemplating to start the proceeding or you should not, it
Not
should
sure, I'll
not
obtain
take so
instruction.
long.
Yes.
Suspension order was of which
My
year?
lord, suspension order I have annexed, my lord, it is of the action of the managing committee. My lord, at page 32, annexure 4, my lord, 2010. the action of the managing committee, White Resolution number 2 dated 30/05/2010, placing MD Fakhruddin Lashkar, the superintendent, Silchar Senior Madrasa under suspension for custody for jail is hereby approved. So, my lord, suspension date is
5,
35/2010.
2010.
From now, it is, my lord, almost 16 years, my lord.
Lordship,
Half of my life.
And no subsistence allowance also
Lordship, may I read paragraph 5, your Lordship, if your Lordship peruses paragraph
of
5?
your affidavit?
Yes, your Lord. Page 4, your Lord. Page 4, no?
কি গরম হচ্ছে এটা? কি বাড়া দিও?
No, it took page, it took page.
85.
85.
No, my lord, it is now chronological page number, my lord, is.
Paragraph 5.
Paragraph 4. Paragraph 4.
5.
My lord, can
84.
take up page 83 and my learned friend is referring to paragraph.
Lordship, paragraph 5,
5 is 84.
Lordship, the second paragraph,
Mm.
further in view of the judgment and order dated 26/8/2016, passed by the Honorable Court in so and so, the government of Assam issued a letter. This is the order by which the earlier provincialization order was set aside, your Lordship.
Provincialization list was set aside.
Yes, your Lordship. Issued a letter to the Deputy Commissioner Kachar for fresh consideration of provincialization order of Silchar Senior Madrasa. The government of Assam also directed the Deputy Commissioner Kachar to expedite the process of scrutiny of teaching and non-teaching staffs of Silchar Senior Madrasa under the Assam Madrasa Education, Provincialization of Services of Employees and Reorganization of Madrasa Education Institution Act 2018.
Mm.
So a new act was brought in, your Lordship. So the DC, the Deputy Commissioner was asked to, was directed to expedite the
So
process
be no more fresh consideration of it.
under the new act, your Lordship.
Under the new act.
Yes, your
Okay.
Lordship.
Under the, and that process, my lord, I have brought my lordship's notice to this order of, my lord, district scrutiny committee's
Lord.
minutes at page 89.
Lordship, then thereafter,
Okay. I'll look into that. Wait. Then,
thereafter, as per direction
Mm.
of the government of Assam, the then Inspector of Schools submitted a letter along with the report of the District Scrutiny Committee for Silchar Senior Madrasa Kachar on so and so, wherein 19 numbers of teaching and non-teaching employees were recommended.
Hmm.
However, in the said recommendation, the name of the petitioner did not appear, your Lord.
Mm.
Next, your Lordship, it is also stated that apart from that, no madrasa institutions were provincialized as per the provisions of the Assam Madrasa Education so-and-so Act 2018, your Lordship. Further, as per notification dated 12/2/2021, issued by the Principal Secretary to the Government of Assam, Secondary Education Department, all the madrasa institutions were reorganized as general schools, and all the notifications, circular order is superseded by this said notification.
Mm.
Moreover, in the meantime, the Assam Madrasa Education Provincialization of Services Act 1995 and also the 2018
Mm.
has already been repealed by enacting the Assam Repeal Act 2020, your Lordship.
Acha, that 18 at 95 both goes.
Both goes, your
Huh.
Lordship. So then, your Lordship.
And now these madrasas are reorganized as general school.
General schools, they will come under the secondary schools, your Lordship.
Hmm.
That your deponent further begs to say that since no formal notification or office order was issued regarding the provincialization of the petitioner after the earlier order of the provincialization dated so-and-so, which was set aside by this honorable court by judgment dated so-and-so. Thereafter, the petitioner has never been come under the jurisdiction of the Department of School Education, your Lordship.
So this madrasa was also reorganized as general
Yes, your
school.
Lordship, yes,
And in a new, this provincialization list,
Lordship.
teachers of the madrasa are there. Same madrasa are
Lordship,
there.
if the madrasa was provincialized earlier, they will now come under the Secondary Education Department by the repealing act. So the instructions that I'll have to bring is that whether this school was this madrasa was provincialized or not. And if it is provincialized, then the teaching staff and the non-teaching staff will be provincialized, your Lordship. And why he was not provincialized and why the Lordship, the disciplinary proceedings have not been taken against him, that instructions I'll have to bring.
Those instructions you
Yes,
have to
your
bring.
Lordship. Whether this institution has been provincialized or not, the concerned institution, your Lordship.
Mm.
Because
Any other teacher from this
Lordship,
institution in the list?
I'll have to obtain instructions.
You have to
Yes,
see.
your Lordship, because
You
here
are,
in the affidavit.
what do
it
you
is
say?
clear.
Any other teacher from the madrasa in the list, new list?
No, my lord, there is no provincialization order had yet been issued, my lord.
No
The,
problem.
the list which I have brought into my lordship notice is the minutes of the district
Hmm.
scrutiny committee. my lord. So therefore, my learned friend is very correct, my lord. This statement which has been made, my lord, under the 2018 reorganization of the Madrasa Act, not a single madrasa, including this, had also been, my lord, provincialized, because before this act came into effect, my lordship knows that all the madrasa institution in our state is now converted into general schools.
Hmm.
While doing so, this 1995, 2013 and 2018 Act were repealed by way of the repealing act of 2020. my lord.
Hmm.
So before any effect could be given to the 2018 Act, my lord, all act goes. Now only one act survived, my lord, that is the Schools Act, my lord.
Hmm.
That is the issue.
What act?
The Assam Venture Educational Institutions, Reorganization of Educational Institutions and Provincialization of Services Act 2017 is the only act surviving at this moment, my lord.
Hmm.
So if the school has to be, if it is not
Right.
provincialized and if it has to be
So let the
provincialized.
instructions be
Yes, my lord,
brought.
that instruction may come and my lord may kindly
But
appreciate
according
my-
to you, the school has not been
No,
provincialized.
lord. Once the my lord honorable court has interfered with the provincialization order, my learned friend can also obtain instruction that whether after the interference, whether a parallel or similar subsequent provincialization order had already been issued or not. That instruction is also required, my lord.
Because in our affidavit, we have stated very clearly that no school has been provincialized under the
Correct.
18.
2018, your lordship. The Madrasa Act, your lordship.
Okay, you bring instruction.
Got
I'll
it.
just give the main particulars.
Lordship.
Okay, heard Mr. A.R. Bhuiya, learned counsel for the petitioner, and Ms. D. Mushahari, learned standing counsel for secondary education.
Secondary, your lordship.
Secondary education. By this application, filed under Article 226 of the Constitution of India, the petitioner has challenged the meeting, the minutes of the meeting.
No, my lord, I am challenged the suspension, page 16, my prayer.
You have challenged the suspension as well as non-inclusion of your name.
Name. No, my lord, because that non-inclusion I could come to know only by your.
Oh, yes, you said that. Okay. Challenging the suspension order
And my
passed
lord,
in respect of the petitioner on, what was the date? On 35, 2010, right?
my
2010. As well as
reinstate.
to reinstate the petitioner as superintendent of Silchar High School, and also for payment of subsistence allowance and as well as a direction to the school Kachar district inspector of schools,
Right.
Kachar district circle, to dispose of his representation.
Right.
The case of the petitioner is that he was appointed
As a
on 1/4 as a superintendent of where is that superintendent of Silchar Senior Madrasa on 1/4/2001, and yes, he was appointed, and his appointment was approved by order dated
30/12/2003.
30/12/2003 by the Deputy Director Madrasa Education Assam. Thereafter, due to pendency of some criminal case, the petitioner was placed under suspension on 35/2010 as stated above. And as stated above, full stop. It is stated by the learned counsel for the petitioner that during the period of suspension, the petitioner's service was regularized, provincialized by order dated 27th of December 2023. With effect from 1/1/2013. And a criminal case which is instituted against the petitioner and others resulted in an acquittal, both of the petitioner as well as the other accused person. Full stop. However, the learned counsel submits that pursuant to the suspension order in the year 2010, no disciplinary proceeding nor any charges were given to the petitioner. What did I say? Any disciplinary proceeding
Had been instituted.
was started. Nor any charges were. What do you say? Statement of charges, allegations, what?
Statement of-
Cause, show cause notice.
Charge memo had been issued, my lord. No any charge memo.
And nor any charge memo has been issued to the petitioner. It is the further case of the petitioner that in a proceeding before this court by similarly situated teachers, this court had interfered with the provincialization order by which the service of the petitioner was provincialized. That is,
Lord 27/12/2000.
that is the provincialization order dated
27/12/2013.
page number 27.
No. Yes, page number.
I just had, yes, 27th
12.
12/2023.
No, my lord. It's 15. 2013. my lord.
Oh, this is the new one.
My lord.
Where's the earlier one?
27/12/2013.
Page 36.
Aha.
Annexure 6, my lord.
Page
36, Annexure 6.
36. Yes. 27 December 23. No, this is the earlier one or what? Oh, this is the later one or what?
No, my lord, it is.
No, this is the one.
No, my lord, there is a typo. My lord, can kindly peruse the original one, my lord.
Acha.
Original one is at page 39, dated 27th
And,
of December.
December 2013.
13. I'm sorry, my lord, there is a typing.
I thought it's 13. And in the said order, it was directed that a fresh exercise for provincializing the services of the employees may be undertaken. Did I give the date of the order? The order was dated, what date
My lord, the
of the
order-
judgment?
Yes,
It was there in her affidavit.
26/8/2016.
16, correct.
26/8/2016.
16.
The date of the judgment was 28
26/08/2016, my lord.
26/8/2016.
Fine.
Full stop. It is after 4 years, not 4 years, more than that.
Fine.
4, 5, 6, 7 years. It is after 7 years of the said judgment, the office of the director of a madrasa education conducted an exercise and and the director of madrasa education. Where is that new one?
My lord, now it is at page 89, my lord. This is a district scrutiny committee's.
Oh, yes, this is,
My lord, it is not after, it is on 21st of February 2019, my lord. So it should be after 3 years, my lord.
oh, this is after, 19. It was idea.
Fine. After 3 years.
It is after 3 years.
Fine.
Line to cut it. It is after 3 years of the said judgment. The department had started the exercise, and on 21st of February 2019, the District Scrutiny Committee for Silchar Senior Madrasa held its meeting. And on a threadbare discussion, a list of teaching and non-teaching staffs was enlisted for provincialization under the Assam Madrasa Education, within bracket, start bracket, provincialization of service of employees and reorganization of Madras educational institutions and reorganization of Madrasa educational institution, close bracket, Act of 2018, wherein the name of the petitioner does not find place. The Learned Counsel for the petitioner submits that there was no impediment to include the petitioner in the said list, inasmuch as before including the petitioner in the erstwhile provincialization list, entire exercise was undertaken. And he, the petitioner, was enlisted in the said list, which is, however, interfered with by this court. Ms. D. Mushahari, learned standing counsel for the secondary education, by relying on the affidavit filed on 10/2/2026, had stated that there is a decision, had stated that the said Act of 2018 as well as the earlier act, namely the Assam Madrasa Education, within bracket, provincialization of services, Act 1995, were repealed by Assam Repealing Act of 2020. Full stop. She further submits that none of the madrasas were provincialized under the 2018 Act, and that there was a decision to convert, where was this regular school?
Also, it is,
You had read page 83, right?
also, which is, 94.
92, my lord. On affidavit, page 92, a notification dated 12th of February 21.
Oh, yes, there was a decision. There was a notification, not a decision. She further stated that there was a notification dated 12/2/2021 by which it was notified that all the madrasa institutions were reorganized as general school, and the said notification superseded all other notifications published in this field. Full stop. Para. However, Ms. Mushahari has no instructions as to whether the petitioner, whether the school, whether the madrasa where the petitioner was appointed is notified as a general school, as a what general school
General school.
was organized as a general school, and whether the authorities concerned have contemplated to start a disciplinary proceeding against the petitioner, who is still under suspension. As such, the Learned Counsel is directed to get the instruction from the concerned authorities as soon as possible. List this matter on, don't delay it, he has not got any money. So list this money on, matter on 21st of May, next to next Thursday. Okay. Get telephonic instructions.
Lordship, 21st.
You have already filed affidavit, no more affidavit required.
Lordship,
List this matter on 21st of May.
Obliged, leave go.
obliged. Your Honor.
Maybe, your lordship. My lord, I'm sorry, my lord, item number 5, my lord.
Item 5.
We are under impression that court will be sitting little bit late, my lord.
Court will be sitting late.
Little bit late, we are under
Achha.
impression. That's correct,
Okay.
my lord.
And then item number 5, what happened?
Our name may be, our presence may be recorded, my lord.
Otherwise, it got adjourned, right?
It is already.
So, okay, Mr. Your name, please?
NK Mori.
Let's learned counsel appears for the petitioner.
Applies, my lord.
Item 3. Oh, this is bench 3 matter, right? Okay. So it will go to the respective bench. Likha. Item 3, In the last order, in the last occasion, that is on 4/5/2026, it was reflected that the instant matter relates to bench 2 or bench 3, and the same came up on the set date before bench 4. And by the said order, registry was directed to verify and list this matter before appropriate bench. But today, it is seen that the said matter is listed before this bench, which is taking up bench 2 matters. As such, it is further directed that the registry may re-verify and list the matter before the appropriate bench. That is bench 3. Yes, Miss.
Yes, Lordship.
Chakraborty.
It was order dated 2/2/2026, Lordship.
They have brought some instruction.
I have not received it.
Miss Moshahari has given some instruction. So what hearing?
Lordship,
Some hearing in the matter.
yes, Lordship, personal hearing, I was directed by this honorable court to file one details representation regarding the regulation of my leave period, Lordship. And I have filed already.
Regulation of
Leave period.
leave period.
See, then, Lordship, that representation was filed by me, and thereafter personal hearing was taken place on 10th of February, Lordship.
So that has resulted in something.
Yes, this is the result, Lordship,
Bornali Fukon.
yes, Bonali.
Okay, let me read it. In continuation, I am really that a hearing is conducted. Yes, she is only because of the question of the person sought for from the directorates. So decision is not yet arrived.
Yes, Lordship. Kindly
So
directed to take a decision for as early as possible.
Mm,
This is pending
okay.
since 2018, Lordship.
Yes, right. Today, when the matter is taken up, heard Miss Panchali Chakraborty Bhattacharjee for the petitioner and Miss D. Mushahari for the learned standing counsel for its secondary education. Miss D. Mushahari, as directed by this court, by the order dated 30/3/2026, has placed an instruction received from the Deputy Secretary to the Government of Assam, Department of School Education, dated 7/5/2026, wherein it was stated that the petitioner was heard who had also submitted a written statement, and that after hearing the petitioner, the department for cross-verification of her statement cross-verification of her statement sought for reports from the Directorate of Secondary Education. Full stop. The Directorate of Secondary Education submitted by this instruction that submission of reports got delayed due to various examinations being held during the intervening period. And after the examinations were over, the Inspector of Schools, Tinsukia, the District Elementary Education Officer, Tinsukia, and the Headmaster of Bipin Bora High School submitted the reports regarding the leave records of the petitioner. And the said report were examined by the department. And that after verification, a decision will be taken. As such, the department has sought for some more time to submit the said decision. Accordingly, list the matter after 2-3 weeks or what? When can we
After 2
submit?
weeks, one date may be fixed.
List the matter on 28th of May
Yes, Lordship.
to 2026. On which date, if a decision has been arrived, be placed before this court by the learned counsel.
Obliged, Your Honor.
Board case disagreement. Item 8, someone is there? You're there?
Your Lordship, we needed to file a affidavit, Your Lordship.
Count.
Tapan Kumar Days. Your Lordship.
You
I
had
have-
not filed your affidavit?
No, Your Lordship, I have obtained the instruction. Kindly grant us 1 week time, Your Lordship.
Okay. Miss P. Das, Learned Standing Council, Secondary Education, submits that she has the instructions with her, but she needs some time to incorporate those instructions in an affidavit. Prayer is allowed. List this matter on 15th of May, right?
Yes.
2026.
I'm deeply obliged.
Yes.
Lordship, in this matter also.
We can bench 3.
Yes.
Bench 3 matter.
Bench 3 notes.
It will go to bench 3 then. This is bench 2. Okay. On the last occasion, that is on 29/4/2026, this court, the 2026, the learned counsels for the petitioner had apprised that the present matter relates to bench 3 and the case was listed before bench 5. And as such, this court directed the registry to verify and list the matter before the appropriate bench. However, the matter has been listed before this court, who is taking up bench 2 matters. As such, it is further directed that the registry will re-verify and list the matter accordingly before the appropriate bench. Interim order is there. Interim order passed earlier shall continue till the next date, till the next returnable date.
Yes, 10. Yeah, we don't know, legally the same. May it be pleases you, Lordship. Here instruction awaited, your Lordship, Neetu Kalita. Communication has been made, your Lordship. Kindly grant us 3 weeks' time, your Lordship, to obtain the instruction.
Okay.
Instruction.
Miss P, we heard Miss
PS Ocha.
P.S. Kocha,
BS Ocha.
B.S. Kocha, Learned Counsel for the petitioner, and Miss P. Das, Learned Standing Counsel for Secondary Education. Miss P. Das submits that she is yet to receive her instructions and has prayed for some time. Prayer is allowed. However, it is noticed that on 23/2026, 3 weeks' time was given to the Learned Counsel for the Secondary Education to file affidavit in opposition. Since a lot of time has elapsed, the Learned Counsel is given. No, she wants time. She wants time. She doesn't have the instructions.
Last time also there.
That's what I have written. So 1 week's time. কি বুলি কলো? না পিছৰখিনি কলো না কিবা? However, by order dated 23, but when the matter is called up today, the Learned Standing Counsel has again prayed for time. And in the said facts, it is therefore directed that the Learned Counsel should file the affidavit within a week's time, list this matter on 15th of May again.
Should a little bit longer.
List this matter on
27 Lords, 27.
Yes, your Lordship.
27 is a holiday. 27 is a holiday. List this matter on 26th of May.
26.
26th of May,
26.
2026. I would have given lesser time, but then you said 27, okay.
21.
Obliged.
Deeply obliged.
Yes, Mr. Das. Chaudhary. I always get confused. This is for admission.
Yes, Madam. They go yesterday, it came. Madam.
Oh, yes, yes. Miss Terangpi was there. It's okay. The instructions should be there.
It is decided, Lordship.
Acha, just let me go through the order.
Covered by the division bench.
Please, delivered by the Learned Division Bench, wherein clause. Oh, compassionate appointment.
Yes, sir.
They declared as unconstitutional. 3 years. By the law has been upheld by the Imam.
In my case.
And he submits that the incident is governed by the same. Okay, you have gone through the judgment.
Yes, Lordship.
And so clause 1 remains.
No, Lordship, it is not, is this strike down, Lordship?
Uh-huh.
That
Clause-
clause is not there,
Clause
Lordship. right
one,
now.
clause 1 was held unconstitutional. It has
Uh-uh. And so it is unconstitutional. So clause 1 goes.
Yes, Lordship.
And that division bench has upheld the
Yes.
single judge's order.
Yes.
So there is no clause 1. So there is no impediment that somebody working for 3 years
Less than
will not be allowed compassionate appointment. Somebody who died within 3 years, that is not the case.
prior
So
to
you can
15th
always
May.
consider.
Yes.
while my father died, Madam, the only Madam, that was
During 3 years of his service.
less than 3 years service left, Madam. That is why it was,
Less
Last
than
one.
3 years service left.
yes,
Oh,
It is
it's not the first 3 years of service.
not,
No,
not.
It's the last 3 years.
Last
Hmm.
clause was for.
Show me clause 1 of the office memo. Is it annexed here?
Yes, Madam. At page 32, Madam.
At page?
Page 32, Madam.
Yes. Where is clause 1? Has less than 3 years to retire. On the date from which he has been missing. He has been.
Page 31, Madam, the annexer 3.
Okay. 31 which clause?
Page 31,
Clause 1.
Clause
clause
1.
1.
Only one dependent family member of a government servant appointed on regular basis excluding
excluding one working on daily wage or casual or apprentice or ad hoc or contract or re-employment basis who die in harness or become incapacitated due to accidents suffered while on duty and is eligible to opt for invalid pension under relevant provision of service rule, pension code, and or who is missing is eligible for making application for compassionate appointment provided in each case. The government servant has balance of minimum 3 years service.
3 years of service.
My service, my father's service was left only 2 years, 2 months, only fall short of 2 months, some days, my lord. It was
Short of 2 months for 3 year
Yes.
service. So he is yet to go 2 years, 10 months of service,
my lord,
and he died.
only 2 months,
Left.
less than 2 months, my lord, to become 3 years, my lord.
So he has only 2 years, 10 months of service
Yes,
left
yes,
in his career
yes,
and in his tenure,
Yes.
and that he died,
right,
right?
right.
But here,
So
who die in harness,
that,
okay.
that clause doesn't
Right.
affect me, my lord.
So your heir dependent can apply.
Yes. It was
Right.
recommended by the district level committee and only the state level committee rejected my case.
On this ground.
Yes, my lord. And that is why, my lord, as per the judgment of the division bench, my lord, I am entitled to consideration.
Mm.
Now, Lordship may direct the authorities to reconsider my case.
So, okay, authorities to consider since clause 1 will not apply.
Okay.
That is the case, Miss
Noted.
UMS
S4.
Kuon. Yes. In between, I had not been in the bench, so I forgot the names. So, Miss Kuon, you have gone through and you agree with this proposal, right?
Lordship, send back it to the SLC, Lordship.
Send back to the state level committee
Yes, Lordship.
who will reconsider the
Yes.
case. Where is the rejection order of the SLC?
Yes, at case 48. we will see. Yes. Minus of the meeting. we will do. In my case, my lord, at case 42. Serial number 34.
But here, Lordship, one
Yeah.
problem is here, Lordship. The petitioner annexure 5 as a document, Lordship, but the complete document is not here, Lordship. Only a portion is annexed
Yes,
here.
yes.
What is the page?
Page 44, Lordship.
Case 45.
So
my-
Can we discern the reason?
Yes, Lordship, but because there was no date. That should be.
Rejected
mentioned, Lordship,
list.
When
You
the
are-
SLC was.
Date is given on 5th February 2021.
Portion, and lastly, after having gone through all the relevant records. Complete list. should be-
Minutes of the meeting that was held on
Minutes should be annexed, Lordship, complete minutes.
4/1.
No, where are you? What is your name?
my lord, at page 48, my lord.
No, what is your name?
Nitul Burman.
Nitul Bormon.
Nitul
So
Burman.
Nitul Bormon, remaining service period of deceased,
Yes,
government employee was less than 3 years. So that is the reason.
yes.
You said the entire list is not there. Or what?
No, list is there, my lord.
Yes, Lordship.
Gone through, after having gone through all the relevant documents received from district level, the state level could not recommend the following. So what full document you wanted?
No, Lordship, the annexure, the petitioner mentioned only about the annexure 5, Lordship, and it was a typed copy.
Huh.
The main copy was behind the 45, page 45 was started, the original copy.
Hmm.
So I have only seen only the 44, page number 44, Lordship.
Hmm. That this is the
Yeah.
original document.
Yes, Lordship, page 46.
And where is the rejection of Nitul Bormon?
Yes,
Page
48.
48.
Serial number 34.
Okay, they have translated part of the
Yes,
document
yes,
which is
Lordship,
relevant.
Yes,
So Nitul, where is that?
In Rajan.
34. First one, Lordship.
Oh, first one.
48, first one.
Again, it got smudged. Same thing, they have not typed out the entire thing.
Remaining service period.
Rejected list.
This is government employees was less than 3 years.
I've
Only
seen that.
2 years, 7 months, 10 days.
I've seen that, Mr. Chaudhary. And what about this? See page 47. This is continuance of some other pages. These pages you have not added. You have left out. There are many pages over.
No, not many pages.
No, see
Yes.
page 47.
Page 47, my lord,
This starts with serial number 21.
no, my lord, this is a separate list for rejection of the less than 3 years.
No, I understand. The later part is rejected list,
Yes.
but I wanted to see the full document. The first part is with respect to the allowed candidates,
Allowed.
but then the entire document is not here.
Not.
What about the,
24, it is entire document actually.
no, what
One
about
to-
the earlier candidates before 21? It starts with
Yes,
21.
yes, ma'am. Yes.
That you have not annexed.
Allowed regard so far, my.
Here also they have annexed the things
Half
that they are
agreement.
data required. And Miss J. Kumar,
It's more.
S. Kumar, Learned Counsel for the Learned Standing Counsel for,
No, Lordship, for government advocate.
oh, Learned Government Advocate. And Miss Mushari was also there. And D. Mushari, Learned Standing Counsel for Secondary Education. Petitioner has challenged the decision of the state level committee in its meeting held on 4/1/2021, by which the prayer of the petitioner for compassionate appointment due to the death of his father in harness was rejected. Kibuli Kolo has challenged the state level committee. Okay. Anything else, answer? The learned counsel appearing for the petitioner had submitted that clause 1 of the office memorandum. No, before that you write, huh? The learned counsel for the petitioner submits that the request for appointment, the request for compassionate appointment by the petitioner was rejected by the state level committee on the ground that the father of the petitioner had died in harness when he had less than 3 years of service to retire. Full stop. The learned counsel submits that clause 1 of the office memorandum dated 1st June 2015 provides that a dependent family member of a government servant who dies in harness is eligible to apply for compassionate appointment. But if the government servant does not have a balance of minimum 3 years of service left in his tenure, the request for compassionate appointment will not be adhered to. Full stop. However, he submits that the said clause 1 of the notification was challenged before this court and by learned single judge. Where is that? In writ petition Bhaskar Kumar.
Yes.
In writ petition number 1646 of 2021, that is in Bhaskar Kumar versus State of Assam and others. Where is the conclusion and finding? Held that said clause 1 of the said memorandum is violative of Article 21.
Yes.
Where is that finding?
14.
Page?
I marked there, Melody, in this.
Page 19
Page 13.
is unconstitutional. Okay. Being violative of Article 14, was stated to be unconstitutional. And the said provision was struck down. Full stop. Against the said decision, the State of Assam had preferred an appeal, being writ appeal number, preferred appeals, Lydia, preferred appeals. One being writ appeal number 287 of 23, challenging the, starting or line to ki? Against this said decision, filed appeals, which was disposed of by a common judgment and order dated. What is the date of the judgment?
25. 12/12/25. 2025.
12/12. The copy of the order, the date of the order is not reflected in the copy that you had given. So it is 12/12.
2025.
12/12/2025.
Last page.
By which
The finding of the single judgment, that paragraph 19.
I found it. By which the judgment of the learned single judge was upheld. But there was the amended memorandum, right? 14/9/2017.
That is separate memorandum. They are abolishing this office memorandum regarding entitlement of compassionate appointment.
In place of compassionate appointment, compassionate family pension.
After 2017, it was replacement.
It has got nothing to do with this case.
No, nothing. My case is covered by the 50.
And where is the finding of the division bench?
Division bench, Melody. From paragraph 19, you will find it. New policy is not applicable.
Acha, which is not applicable in case of the respondents.
Yes. In 18, paragraph 18, now the question to be decided is whether it was appropriate for the learned single judge even while taking cognizance of the supersession of the
Ki করলো?
member.
By? It was upheld. It was upheld by the learned division bench. The conclusion of the learned division of the honorable division bench is quoted here under 17 paragraph to quote kori diba, huh? On these grounds, we find that the declaration of clause 1 of office memorandum to be constitutionally invalid is wholly justified. Okay, eto tumi quote kori diba. As such, it is seen that clause 1 of the office memorandum dated 1/6/2014 is struck off as stated above. In view of the same, or no, like in view of full stop, the petitioner in this case had stated that when his father died, no, like it no, cut it, yeah? The case of the petitioner in this case is that his father was serving as the assistant teacher at Raj Kadamtal Balika Vidyapit High School at Paikar Kuchi, Nalbari. And that while he was working in the said capacity, he died on 21/7/2016. The death certificate of whose has been annexed in the instant petition. The petitioner had further stated that his father rendered total length of service being 24 years, 8 months, and 2 days till his death. It is the further case of the petitioner that after the death of his father, the entire family went into severe misery as his father was the sole bread earner in the family. Full stop. The petitioner had already he had already done his graduation from Nalbari College, and he applied for a job before the inspector of schools, Nalbari, for his appointment as an assistant teacher. Full stop. He came to know about the office memorandum dated 1st of June 2015, and he being eligible made an application for compassionate appointment before the authorities concerned. He thereafter stated that the district level committee considered his application and recommended his name for appointment on compassionate ground for the post of grade 3 within bracket LDA against OBC/MOBC vacant post. Full stop. The district level committee, after a meeting, recommended his name to the state level committee for consideration. Para. Full stop para. It is the further case of the petitioner that the state level committee held its meeting on 4/10/2021.
401.
Huh?
401/2020.
Oh, 4/4/1/2021, huh? January 21. And held inter alia that the petitioner's case cannot be recommended for compassionate appointment as the remaining service period of his father, the deceased government employee, was less than 3 years. Full stop. Less than 3 years, comma, yes, comma, the inability, in view, na comma no, in view of the disqualification mentioned in the office memorandum, mentioned in clause 1 of the office memorandum, dated 1st June 2015. Full stop. As such, the state level committee did not recommend the name of the petitioner for compassionate appointment. This judgment was during the pendency of this petition.
Division
we-
bench.
Huh?
Division bench.
Hmm?
Not my lord.
No. So you had mentioned the about the judgment in the petition.
Yes.
Acha. Para. The learned counsel for the petitioner. No, you have not mentioned, no?
My lord, the repetition number, we have not mentioned.
Acha.
Only
Wait. When did you file this?
while appeal was.
This was September. So this was disposed in December.
Yes.
You had your learned single judge's order.
Yeah. Both.
No, it's there with me. Matlab, during the pendency of this petition.
Pendency of this petition, my lord, I did not have the order also, my lord.
Single judge's order was after this.
No, my lord. Before that, my lord, but I could not obtain the single judge.
Achha. It's okay, I'll not mention that. Okay, so para. The learned counsel for the petitioner had placed that clause 1 of the said memorandum was challenged in writ petition number 1646 of 2021. And this court, by order dated 30/1/2023, held that clause 1 of the said memorandum is unconstitutional and accordingly had struck down the provision. Against that, the state had filed appeals as stated above, and the Honorable Division Bench had upheld a decision of the learned single judge by order dated 12/12/2025, right? 12/12/2025. In view of the same, the Learned Counsel submits that there being no impediment for consideration of the petitioner for compassionate appointment, and the reason for the rejection of his appointment by the state level committee becoming otious, the prayer of the petitioner may be considered by the state level committee. In view of the said facts and circumstances, this court therefore thinks fit you will again file an application or what? Your application is already there.
Already dear, my lord.
Thinks fit that the state level committee may reconsider the case of the petitioner in the light of the judgment passed by both in the writ petition as well as in the writ appeal.
Lord, if it is said may, my lord, then.
Oh, may no.
Shall consider.
The shall. May ko suno, shall go. Shall consider the case of the petitioner in the light of the decision passed in so and so. Full stop. It is not required to be mentioned, but for the ends of justice, this court directs that the petitioner's case was already recommended by the district level committee and there is no need for the petitioner to file a fresh application for compassionate appointment, and that his case shall be considered by the state level committee. Full stop. It is further directed that the committee may consider the application within a period of, may consider his case within a period of 2 months. Within a period of 2 months. Okay. 2 months from the date of receipt of the order.
Okay.
The petitioner is directed to place this order before the state level committee for his reconsideration. Petition is disposed of. Contempt case. Yes, Mr. Bob Pujari, you are for the contemners.
Yes, my lord. My lord, here what has happened, my lord, against the order passed by the learned single judge, which is put to contempt here, my lord. The state had filed an appeal before the Honorable Division Bench. That has been dismissed on 27th of November last year, my lord. Now, thereafter, this contempt petition stood revived. Now, I am representing, my lord.
During the pendency of the contempt petition, the appeal is disposed.
Dismissed. It is dismissed. So, my lord, the order passed by the learned single judge stands. And my lord, by the order passed by the learned single judge, an amount of rupees 10 lakhs was directed to be paid as compensation to the petitioner for my lord alleged death of her husband. Now, there is a scheme promulgated by the state of Assam, whereby under those circumstances, an amount of 3 lakhs is required.
That is 357.
No, my lord,
Victim compensation.
the victim compensation. Apart from that, there is another scheme, my lord, promulgated by the Revenue and Disaster Management Department, whom I am also representing, my lord. Now, during pendency of that appeal, my lord, an amount of rupees 3 lakhs was paid to the petitioner.
3 lakhs.
3 lakhs. So now, my lord, the balance amount of 7 lakhs is required to be paid. Now, for that, my lord, the authorities are required to take the approval of the cabinet because it goes outside the scheme, my lord. That is one. And secondly, most importantly, my lord, none of the incumbents who are arrayed as respondent contemners are no longer holding office. So that is the difficulty on my part to get the instructions, my lord. Otherwise,
So those have retired.
yes, my lord. The
So then you have to implement the new
yes,
incumbents.
because none of the respondents are here. My lord, whom I am
But the
referring.
problem is, because the applications are being delayed. So people gets retired and the list of respondents gets
No,
increased.
that is true, but my lord, if now if the petitioner impletes the fresh incumbents, my lord, it will speed up the matter. It will immediately.
Okay, you
speed
file
up
an
the matter.
application, what to do? They have
That is-
retired.
Yes, my
No
lord.
issue, man.
They will also be
That is-
there.
If my lord, if my learner felt
No,
like pain to
I
started matter.
am taking all the pain, my lord, to get the instructions from the department, but department says, my lord, because that will be an instruction placed as if, my lord, I am placing it before a read court. Because the respondent number one, my lord, who was the erstwhile chief secretary of the state, he has retired long ago, my lord. And similarly, all the respondents are no longer in office. So therefore, getting the instructions from the department, my lord, it takes some time, my lord. Otherwise,
There is no instruction. I don't think so. Because compensation, as has been decided in so many cases,
yes, my lord, now we are in a.
Upahar, I'm not talking of Upahar, but also erstwhile cases.
Yes. There
Some
is.
lady's name, Mala, what was that? The case of 3 judges bench, where palliative amount was supposed to be paid
Yes.
and the rest he can get it from the civil court.
Yes,
Right. And later on it was changed.
yes,
So any amount of compensation can be given.
yes, my lord.
So 10 lakhs is a reasonable amount.
It is a reasonable amount. I am not even, my lord, going into the merit of the order, my lord, because that order has certain finality, my lord. We are bound to comply. My only endeavor is to, my lord, to assist this honorable court. If he, my lord, impletes the present incumbents, that will speed up the matter, my lord. Only to that extent. That is one limb of my lord submission. Second is, my lord, there is a glaring disparity, my lord. The order that has been put to contempt, while we had preferred a writ appeal, my lord, it came to the notice of the Honorable Division Bench that that order was not complete. That original order consisted of, my lord, 31 paragraphs, but only 20 paragraphs were uploaded in the website. So accordingly, and that order is also a part of the present contempt proceeding. So it is incumbent on the petitioner's side,
Will
my
file
lord,
additional
to file an additional affidavit and bring it on. So that will regularize.
That's a fact.
It's a
Otherwise, maybe the paragraph numbers are different.
Yes, that has been noticed, my lord, during the course of writ appeal, my lord.
Ah.
appeal, and in fact, my lord, the Honorable Division Bench
was
has ordered
rectified.
for an inquiry to that effect, my lord.
Mm.
And I am having that order, my lord, right now with
It's
me.
okay, it's okay.
Yes.
So what you do is you don't want to implement
Yeah,
them.
we will, definitely, my lord. No option, no.
Okay, you file 2 applications, one implementing and the other you bring the
My
entire.
lord, Lordship may give us liberty to implement. In the meantime, we'll implement
Absolutely,
and also we'll file necessary additional affidavit, my lord. So
Okay.
far that order part is
That
concerned.
will only, my lord,
Mr.
speed up the matter, my lord.
Uh-huh.
Yes.
Mr. B. Borpujari,
Our Borpujari.
R. Borpujari, learned counsel for the respondent number 1 and 2.
One, my lord.
Learned counsel for respondent number 1 and 2
My lord,
has intimated.
Only one, my lord.
Or respondent number.
R1. I am representing R1.
Who is representing R2?
R2, my lord.
You are there.
Respondent number 3.
Wait, there are so many respondents. Oh, Kumar Sanjay Krishna. Then you are for R1.
R1.
Now you will be for the whatever.
My lord, whatever, they will.
Yes. And 2, 3, 4, so many respondents.
None of they are now holding office. To my information, my lord.
And whether they are required to be parties.
They ought to be, my lord, because otherwise, my lord, it is the Revenue and Disaster Management Department who is going to, my lord, comply with the order. So therefore, my lord, the appropriate officer of the Revenue and Disaster Management Department needs to be implemented as a party respondent, number one. Then, my lord, the appropriate officer of the Home and Political Department.
Home and Political Department.
Home and Political Department, and my lord, the yes, that much.
Home and Political Department. Oh yes, Home Department.
Yes,
Ashutosh Agnihotri was there. He retired.
my lord.
Transferred. Retired.
So nobody is holding office right now, my lord. There were originally 7 respondents, as lordship will see, my lord.
So implementing of the new chief secretary, the secretary of the Home Department, and
Chief
Home.
Secretary not required, my lord.
Huh?
Chief Secretary not required.
You said respondent number 1 and he retired.
Respondent number 1, I am appearing, my lord. Now, since he is no longer holding office, now to speed up the proceedings, my lord, since it is held up for technical reasons, to speed up the proceedings, my learned friend, may include, my lord, the appropriate officers of the Revenue and Disaster Management Department, number one. Number two, my lord, the appropriate officer of the Home Department.
Okay,
That much.
let him decide
will
that.
do, That will do, that.
Okay.
He is aware.
And direction to whom was given by the single judge?
Direction to, my lord,
Authorities.
to the state authorities, more
State
particular.
authorities.
She may clarify for better, my lord. Otherwise,
Okay, you include whoever you want, you think is required.
No, Lordship may indicate in the order, otherwise it will again difficult for us, my lord.
He said disaster management and home.
Yes,
That will do.
yes. At this stage, my lord.
Okay. Mr. R. Borpujari, learned counsel for respondent number 1, submits that respondent number 1 had retired and that
My lord, from respondent number 2 to 7, my lord, to my information, they are now no longer holding office, my lord. In the
respondent number 1 to 7,
One
he
to
submits that respondent number 1 to 7 have retired from the said post and that to get the instructions, he submits that the new incumbents may be impleaded. To which learned counsel for the petitioner, Mr. N.K. Mori, agrees to the same. It is also submitted that the authorities who are required to follow the learned single judge's order, which is upheld by the Honorable Division Bench, are the Commissioner and Secretary to the Government of Assam, Revenue and Disaster Management.
No, my lord, that post is no longer there, my lord. It will be the additional chief secretary.
Oh, acha.
Additional
Okay.
chief secretary.
Additional Chief Secretary to the Government of Assam, Revenue and Disaster Management,
My lord,
as well as the Secretary to the Home Department,
my lord.
Home and Political Department.
They will have to be
However,
implemented by
petitioner-
name, my lord.
Huh?
They will have to be implemented by name, my lord.
Yes, yes. Hmm. Secretary means the name only.
Yes.
As such, it is directed that the petitioner may file an impleading application for impleadment of the necessary parties in the instant contempt application.
My lord, instead of
Further?
necessary, Lordship, my lord, if Lordship may say, instead of filing necessary application, we will implead.
No, it is for actually the prayer should come from you that I will file an impleading application, impleading these new incumbents.
No, yes.
Prayer has come from him.
Instead of filing
I am-
application, my lord, that's what I'm saying. Otherwise, again, we will file another application, again, after allowing the application, if we go by normal procedure, my lord. Then it will only be
We have to
impleted.
follow the procedure before a constitutional court, my lord.
No, if-
No, not required. You
if
will file your
anyone
impleading application. Okay.
will-
Further, it is brought to the notice of this court that the learned single judges, that the judgment and order passed by learned single judge was annexed, which was incomplete in nature. As it is stated that the incomplete judgment and order was uploaded in the website. As it was stated that an incomplete judgment and order was uploaded in the website. As such, the learned counsel makes a prayer that he will file an additional affidavit to bring into record the complete judgment and order passed by the learned single judge. Prayer is allowed. List this matter on when do you want? You will file an additional and an impleading application. List this matter on 10th of June 2026 for further orders.
may be given liberty to communicate the order, otherwise completing it will be difficult.
We will always have the liberty to communicate the order. What order you want to communicate?
Now,
Because earlier order, my lord, if I'm filing additional affidavit, my lord.
You take
You-
out the proper order certified copy
Yes.
without getting it from the
Yes, yes,
website?
Yes.
It is now available in the website.
Oh,
madam.
it's a
The
correct copy is
correct,
there.
Yes, yes. I'm so obliged.
Oh, 1 to 7, 1 to 7. Oh. He appears for 1 and he submits that all of them had retired. 1 to 7.
Obliged, my lord.
I'm so obliged.
It's okay.
Readings are not complete.
Acha. Contempt, writ petition, everything together.
Everything together, my lord, pertaining to
Hmm.
item.
Otherwise, service of notice is complete. You will file affidavit. You are appearing for?
Your Honor, I'm appearing in item 14 and 15. In 14, I am the petitioner. Your Honor.
Yeah, I am?
Petitioner in item 14.
14, he is petitioner, I am private respondent.
Acha. Okay, what about 12? 12, you are required to file affidavit, Ms. Mushahare? 12. Ms. D. Mushahare, Learned Standing Counsel for Secondary Education, submits that the instructions have not been received and as such has prayed for some time. Prayer is allowed. The Learned Counsel is permitted. No, prayer is allowed. List this matter on. When can you bring? List this matter on 2nd of June, 2026. Okay. Then what about 13? This is a contempt application.
Others may come along with the, this, okay, 12.
Contempt, who is appearing for contempt? He cannot appear for the department. It's a contempt by name.
He'll be representing the contempt.
It will also. Hmm?
The contempt.
So there are 4 respondents. Vijaya Chaudhary, U. Sharma, a standing counsel has accepted notice on behalf of 1, 2, 4, and 5. That cannot be the.
Lordship, because
I think this order is passed in all the 4 petitions.
Lordship in all the.
But somebody has to appear for the contemners.
Notice this.
I think none of these contemners are also no longer holding the post.
Then you have to again.
I'll take instruction. I have been newly engaged in it. I'll
Okay.
obtain instruction.
Mr. Sharma, what Sharma?
S. Sharma.
S. Sharma, Learned Counsel for the petitioner submits that the respondents in the instant contempt application submits that it is to his knowledge. That it is to his knowledge that respondents in the instant contempt petition have retired and he has paid for some time to get the proper instruction. List this matter again on 2nd of June. Then 13. 13,
13.
Oh, no.
14.
14.
14, I am appearing for the private respondent.
Acha. And 14, you are there for the petitioner?
Yes.
You are Mr.?
As Difusa, appearing on behalf of D. Chaudhary.
Acha. This is a writ petition.
Yes.
Here what? Ms. Mushahari, you are there?
Lordship, it's similar because we'll have to obtain instructions because.
You?
I'm respondent was sick, private respondent.
You had filed your affidavit?
No, madam, I will pray for.
Somebody has filed affidavit. This, who has filed?
We have filed.
Abdul Qadir. I am the writ petitioner. You have
Yes.
affidavit by the petitioner. You had Mr. Chaudhary's
We must have-
representative. You had filed one petition, one affidavit. Okay. Ms. Mushahari, you file your affidavit and Mr. Sharma,
Lordship, I'll tell you.
you'll file affidavit.
I'll tell you.
Heard Mr.
As Difusa.
S. Nefusa
Difusa.
Nipusa, Learned Counsel appearing for
D. Chaudhary.
Mr. D. Chaudhary, Learned Counsel for the petitioner. Ms. D. Mushahari, Learned Counsel for the secondary education, as well as Mr. S. Sharma, Learned Counsel for respond number
6, ma'am.
6. Prays for some time to file affidavit in opposition. Prayer is allowed. List this matter on 2nd of June. What about 15?
15, I am for the petitioner, my lord.
Okay,
State is to file affidavit.
We have
state to
not-
file affidavit.
Lordship, we have not obtained our instructions yet.
Uh-huh,
We have not obtained our instructions yet.
okay. Heard Mr. S. Sharma, learned counsel for the petitioner. Ms. D. Mushahari, learned standing counsel, prays for some time to file, to get the instructions and to file the affidavit. Prayer is allowed. List this matter on 2nd of June.
Obliged.
Very, Tika, Dorothy, to me, I'll give a judgment, division bench. Again, bench 3 matter.
Yes, Lordship.
Why bench 3 matters are being listed before bench 2? It is specifically written that it is bench 2. Or what? Here কি লেখা আছে দাদা? হ্যাঁ এটা কি বেঞ্চ দিছে? 2 হে কিন্তু কত রিফ্লেক্টই করে না দেখুন। না করা। ডিভিজন বেঞ্চ 2 হেতু বেলেগ। চাও মোৰ ৰোস্টাৰটো চাও প্ৰথম দিনৰ হেৰিটো। মোৰ ৰোস্টাৰটো নাই। প্ৰথম দিনৰ মানডে যিটো ৰোস্টাৰ ওলাই। Wait, let me check up. What bench this is taking? Huh?
Perhaps Malady was not assigned any matters in the roster, but to the best of my recollection, because Malady was sitting in a division bench. So no specific roster was allotted to Malady.
No specific.
No specific.
To my recollection, subject to correction.
Who is taking up bench 3 matters, Saksu?
Justice Krishnan Nair, Lordship.
Justice Nair
And Justice Soumitra Soike, Lordship.
Justice Saikia?
Yes, Lordship.
Likha. It is submitted that the instant case pertains to bench 3. Full stop. The registry to re-verify and list the matter before appropriate bench.
My lord, may I pray for a fixed date if it could be on the Monday?
What?
If it could be placed on Monday, my lords. I just need a
As
date.
prayed for by the learned councils, list this matter on Monday, that
Lordship,
is 11th of May.
Lordship, instruction not yet received, Lordship. Instruction not yet received, Lordship.
11th of May, you prayed before the court.
Obliged, Lordship.
I'm so obliged.
May it please
Oh, yes.
This,
17.
contempt petition for non-compliance of the judgment and order dated 21/01/25, my lord.
Acha.
On 19/2/2026, notices were issued, my lord. And in terms of the office note, it seems, my lord, 2, 3, and 6 has entered appearance. And with regard to 1, 4, 5, 8, and 9, AD card has not returned, my lord.
So many respondents to comply with your order.
So many, my lord, as abundant caution, my lord, already made part of it.
So,
Otherwise, 4 and 8
hmm.
is the responsible contemnants, my lord. Respondent 4 and 8, the accountant general and the executive engineer PWD.
Maybe they are no longer here, Accountant General's office.
That instruction I don't have, my lord. We can, my lord, may allow me to take fresh steps on the remaining respondents, or we can await service, my lord, and lordship may fix it after a week or 2, my lord.
The office note was dated 5/5. So
Office
May.
note dated 5/5.
So not very long. Let us await.
Yes, ma'am.
Notice was issued on 26/3,
Yes,
1 to 9.
1 to 9. 2, 3, 6 have entered appearance.
Yes, 7 is also AD card received, services done.
7, my lord, it can be deemed, my lord.
Deemed.
In that case.
And only 1, 4, 5, 8, and 9. So what? Fresh notice or?
I'll take fresh steps, my lord. The initial order says, my lord, by speed post. Lordship may allow us to take steps by
By
speed
speed post. Heard Mr. P. Mahanta. P. Mahanta, learned counsel for the petitioner. You are there in the matter. You are for?
Here is it, there, or respondent number 3. Mr.
Respondent number 3. Okay. And Miss S. Deb, learned counsel appearing for Mr. P. Saikia, learned counsel for respondent number 3. Are you there?
For respondent number 2.
2. Mr. Choliha, what Choliha? A Choliha for respondent number 2. 6, someone is there? 6, Wakalanama is filed. For 6. And Miss A. Sharma, learned counsel, appearing for Mr. R.M. Das, learned counsel, appearing for respondent number 6. It is seen that service of notice is complete as far as respondent number 7 is concerned. However, there is no representation. But as far as respondent number 1, 4, 5, 8 and 9 are concerned, Mr. P. Mohanta praised that he may be allowed to take fresh steps for service of notice upon the said respondents. Prayer is allowed. The petitioner to take steps by speed post. Take fresh steps, by speed post with AD. Returnable by 2 weeks.
Fix a date, any date.
2 weeks. List this matter again on 29th of May,
29. I'm very grateful.
2026.
Maybe, my lord, yes, we have taken steps and how the my lord matter will take with the Lawajama court, my lord.
No service. 1 to 4.
Yes.
There are only 4 respondents.
Yes,
So let us await.
it may take in the meantime before the Lawajama, because nowadays my lord postal tracking reports are available. So,
Place it before the Lawajima court.
yes, but.
Do you need a court's order for this?
Yes, yes, sir.
Okay. Heard Mr.
Be prepared.
B. Purcaster, learned counsel for the petitioner. It is noticed that service of notice upon, it is seen, Bulidia. It is seen that service of notice upon the respondents 1 to 4 is not complete. And the office note reflects that till date, no AD card or unserved notice has been received back. As such, the learned counsel for the petitioner prays that the instant matter may be listed before the Lawajima court. Prayer is allowed. List accordingly.
The date may be given after 2 weeks, man.
No, before Lawajima court, they can list it within a day or 2. Okay. Or you can say the registry to list the instant case before the Lawajima court within a week. Okay. Yes, Mr. Azad.
My lord, my lord.
Writ petition.
In this case, my lord, by the Lawajima court order dated 21/4/26, service is completed, my lord.
Acha.
And this is my first submission, my lord. I would like to submit 1.
6 and 7.
Yes, my lord.
1 to 5 are the state
Yes,
respondents.
They are responded.
They have filed their counter.
No, no, not filed till more than.
You will file, Miss
Madam,
Decca.
Lordship, SSA is the main party in this matter.
SSA who appears?
B.
Last-
Chaudhary S. Bora.
Last
B.
session they are appeared, I think.
Pune appear also.
Last date, I'm checking.
A. Fukon appeared for elementary 1, 4 and 5. K. Fukon for
SSA.
government advocate. P. Nayak.
K. Fukon,
P. Nayak for SSA.
Lordship,
yes.
affidavit supposed to file by the SSA only.
P9 for SSA.
Elementary education is just a formal party.
How about you? Heard Mr. A.K. Azad, learned
I
counsel.
have just simple one submission, my lord. I would like to peruse the page 24 and accept 3, my lord, for a moment.
Page 20.
24 and accept 3.
Page 24. Wait.
Annexure
24 Annexure 3, yes.
Whereas this district program manager PM Posan Samagra Shiksha Golpara has conducted inquiry dated 6/3/25 at Dalbari Rajyoti LP School, and based on the inquiry report dated 21/3/25 regarding selection of new cook cum helper Monija Khatun, respondent number 6, present, my lord. And as reported that the resolution has fraudulently been passed by the SMC, selecting Monija Khatun as a new cook cum helper on 31/8/24. Subsequently, her appointment was also stayed, my lord, after this order, my lord. Now, I would like to submit how the illegality was conducted at that time.
Let the counter be filed by the other
My
party.
only simple prayer, my lord, at this stage, my lord, kindly status quo. I am praying for status quo because if during the pendency of this case, my lord, they fill up this post, then my case will become.
But then it is already said that this was fraudulently done. So she is what? Under suspension.
Yes, yes. Her yes,
Appointment is stayed.
yes, state. But
By the
subsequently,
department.
if a fresh appointment has been done by the government, my lord, then my case will become effective. That's limited prayer, status quo, my lord.
You had applied for the post.
Yes, I have already, I was already appointed. I am serving long period of time during my working period. I have been removed illegally, arbitrarily, madam. That is my case. That part I would
And
submit.
this Monjila Khatun was appointed in your place.
Yes, in my place, Monjila Khatun was appointed. Now her appointment was going on. That is reflected
state.
from the government order, my lord. That appointment was fully illegal. Now, if my subsequent appointment is illegal, then my appointment is probably, my lord, my removal may probably, my lord, was illegal. So, my lord,
You could have got the order on the very first day itself.
my lord,
Now that you did not get the order, now it is the third, fourth day.
my lord, my lord.
Now let us see what they say.
Limited prayer, if possible, status to if my lord post fill up by them, that I have no case.
Lordship, let
Just
the SSA council file their affidavit after.
till returnable date, status to, my lord. Till returnable date, my lord. Till returnable date. Status quo is not a, my lord, more
Hey,
beneficial for me.
to again pass an, why was she terminated?
Her termination, her allegation against her was that she has conducted some annexure 2 page 22, my lord. No adhering the norms of hygiene while discharging her jobs, cook cum helper, indulging her in practice causing assault to teaching or non-teaching staff. That is the allegation against me. Due to that allegation, I was removed.
So it was done in an unhygienic way.
My lord, ma'am.
So, no status quo. We'll dispose it of after he files the affidavit.
After filing.
We'll have to see whether your termination was wrong or not.
My lord, ma'am.
So there was reason given. It's not that simple termination.
My lord.
Page 22, you had said, right?
Yes, my lord.
So here, communication alleging involvement of Rupjan Nessa, prohibited deceitful conduct towards teaching staff, so and so, cook cum helper.
Present petition. Yes.
Non-adhering the norms of hygiene, indulging in practicing causing assault to teaching and so staff, willful disobedience to headmaster, so many allegations. Let the affidavit come. I heard Mr. A.K. Azad, learned counsel for the petitioner, and Ms. Decca.
Decca for respondent number 1, 4, and 5.
1, 4, and 5. What about others?
Others, Lohajima order, my lord, service completed, my lord.
It is submitted by the state council. You are a state council. Oh, you are a council for elementary. Oh, yes. As well as Miss S. Kumar, learned council, learned state council. It is submitted by the learned councils for the respondent that they require some time to get the instruction and file their affidavit in opposition. Prayer is allowed. List this matter on 21st of May. Will it be too early? List this matter on 4th of June.
4th of within May, if possible.
Lordship, one small part. Kindly reflect that SSA mission director will file the affidavit on behalf of respondent.
It is submitted by the learned council that the Sarva Shiksha Abhijan, SS,
Mission director Samagra Shiksha Abhiyan.
that SSA is the main party, and as such, the learned standing council would also file the affidavit. List this matter again on
within May,
29th of May.
Lordship.
Okay?
Obliged.
Hoga?